doesn't sound as cool. It's cool.
Okay,
I'm very
cool.
tall anyway.
So yes, thank you guys for coming. This is a pretty important one. Got a lot of changes coming down the pike. I talked to some of you in small group this week about some of these. My team has heard about some of these, but we've got several things that we can do today. I don't think we have enough time to do it all, but we are going to do our best to be efficient. So I will do my best, and please let's let Cora do the majority of the talking, and then we can have some time for questions and that kind of thing, so we can cover a lot really quickly. First and foremost, we have reg changes with KREC, law that you need to learn to abide by. We have, and I think that has kind of spawned some of the contract changes that we have, but we also have new contracts, which I'm going to have Cora start with, because I think that's something you need to know immediately because you're writing offers. And then we've got some inspection / like repair kind of stuff that is changing, that is not necessarily KREC or GLAR, but we need to know about that too. So is that
completely accurate.
A fair intro?
Absolutely. Thank you for that introduction. Guys, I may not have made enough copies, which is amazing. Thank you all for coming this morning. But I will just start. If you'll take one and pass it over, we may have to share a little bit. That's a copy of the new contract. How many of you guys, with a show of hands, have written on the new contract this year?
Has anybody yet?
One. All right.
Well, we don't have.
Okay.
We've just gotten. Lana, do we have it in .loop yet?
We've not gotten them set up from Doc.
Yeah, the docs are not in .loop.
Okay, it's out on transaction desk though, so that's good to know in case you're receiving one
I did
on the new
receive
contract. Okay, so hopefully copies are coming around. The one that I made you had the highlighted changes because I think it's just easier to reference that way. First of all, we can all take a breath, and this is not that big of a deal. Yes, it does involve two major issues, but largely I don't think it's going to affect the way that you're doing business. Okay, so let's start with the very heated debate of the concept of surviving closing. How many guys are familiar with the idea of an obligation or provision of the contract surviving closing? Or have you received an offer that said all terms of this contract shall survive closing?
I've received those too. Yep.
Okay, so about more than half the room is kind of familiar with that term. Essentially, the reason why I called it a debate is because it's just that. I had the pleasure of serving on the forms committee when we duked this out, and it was like UK U of L. It was literally a room divided amongst the agents and the attorneys in the room. Reason being, I guess there's two different school of thoughts, just to kind of give you some background. It does involve a legal concept called the doctrine of merger. Is anybody familiar with that? How, you have a closing, it's this thing called a closing for a reason, it's finality, it merges with the deed, the terms of the contract merges with the deed, it's all, the important things like the purchase price are contained in the deed, and we shouldn't have to look over our shoulder after that, right? We have a closing, we've signed our paperwork, let's move on. So there's that school of thought, which I was a fan of, and then there's the other school of thought is, hey, if you promise to do something, you should do it, right? And there's a number of things that make sense for it to survive closing. Maybe naturally some of it gets wrapped up after closing or would take place after closing, and we're going to talk about that. So essentially, as this was debated, we went from the school of thought, the other side saying, I want everything to survive closing, which I'm sure you ran across that, and maybe you're one of those that would always write it in other provisions. And we settled on just having it applied to a number of items in the contract. So I think it's a major improvement over having everything survive the closing.
Okay.
For those title companies that had that in their form at closing for buyers and sellers to sign, they are now going to be, or at least some of them are revising that language as a result of these changes, which is a positive. But I still think you have to be careful. So without further ado, if we'll look to the first page here, okay, we're on page 1, if everybody has a copy to kind of look at, you'll see line 37, the terms of all this paragraph shall survive the closing and delivery of deed. So can anybody give me an example of how that would make sense as it relates to this particular paragraph?
They took a shed that they weren't supposed
Boom.
to.
If they didn't
Okay.
walk through before closing,
Right.
and they get there and realize that this thing's not there.
Absolutely. Let's say you had the 3 refrigerators were gonna stay. You did your walkthrough, maybe you just forgot to check it out, you were excited about closing, you didn't notice it, one of the refrigerators was missing, or maybe they didn't move out until right before closing. Wasn't able to observe that at the time of the walkthrough. So what that means, hey, welcome. What that would mean then, if you notice that one refrigerator was not left, this provision is easily recognizable and referable in that request. Hey, look, you know, you promised to leave the refrigerators. This is your legal obligation. It was not done. I understand we closed, but that obligation survives closing. It's easy to refer to in that manner. Would it have any way? Possibly. I think you can have a good argument. However, this just makes it nice and easy to go ahead and request that that party fulfill their legal obligation, their contractual obligation that survived the closing. Does that make sense?
Yeah.
So that was an easy. Line 41, okay, so as it relates to price and terms, this is important because, you know, if it were ever to be, just to kind of, not to get down in the weeds, but if it were to be tried in a court of law, I don't know how a judge would see all of this, okay? Because in the case law that supports the doctrine emergent, they do talk about the purchase price as it is in the deed. So the fact that it's been added here, I think this particular edition was debated just because it does kind of go against the case law a little bit. But that's neither here nor there. You don't need to worry about it, but I definitely want to kind of give you the full realm of an explanation.
What's the effect?
Let me give you an example.
Yeah, give us an example.
Okay. So, as you can imagine, let's say you have negotiations or repair requests and you alter the purchase price via an addendum. Let's say the title company or the lender or both did not receive that addendum changing the purchase price. We go ahead and close. You would think that somebody would notice the purchase price. That arguably could be the most important thing on your Alta settlement statement. But sometimes that happens. I know it's happened in the past at my office. So rather than it saying, hey, look, you've closed. That purchase price is on the deed. It's final. This now survives closing. So you would have that to stand on as far as pointing out that contractual obligation to make that purchase price right. Okay? So if it was 183 in the contract, you reduced it to 180, but at closing it was still 183. Nobody got the addendum, I'm assuming. Lowering it, then you could make it right after closing, after that deed was recorded.
So to be clear though, this doesn't undo the closing. Okay, the deed transfers at the price that the deed transfers. You could probably amend the deed, correct?
This is a matter of damages, so to speak.
So it's damages. So let's say you did a $2,000 reduction in price in lieu of repairs, and you close the deal at the originally agreed upon $150,000. It was supposed to be $148,000. Let's just say for simplicity it was a cash deal. Okay? The closing is not undone by this surviving the closing. It's just merely that, you know, the seller owes the buyer $2,000.
Right.
And so however they get the $2,000, they get
It's
the
an
$2,000.
opportunity to cure. But to your point, and it's an excellent one, by the way, I think, you know, if that happened in my office, I would do a deed of correction to alter the purchase price because taxes are based on that. You know, the consideration certificate, they're swearing that this is in fact the value of the transfer there. So, you know, I think if that were to happen and we were involved as the closing agent, we would want to have that extra step taken, not just the money changing hands. But hopefully that's more of a rare exception and everyone is paying attention to that. Very important, guys, as this starts to shift and we're going through the contracts, line numbers have changed as a result of all these additions. So if you have stock language or you're used to saying, hey,
Line
you know,
37.
line 37, line, you know, 148, whatever the case may be, you got to readjust that in your head and in your provisions that you keep stock language on because those line numbers may not be the same.
So now that it's in there, do we need to then put the same language in an addendum if we change the price? Does that affect it?
Oh, it does not. Because if you're changing the purchase price as it relates to line 43, let's say they're paying cash, well, that provision still stands. It's a part of that.
It carries
so
through.
you don't have to make reference again, but
Okay.
certainly if like to, you can.
If you do a deed correction, does that cost extra?
Oh, good question. So a deed of correction absolutely positively would cost extra. I would think it would be the burden of the party. So let's say the seller you know, says I was supposed to get more, maybe it's a more money situation. I was supposed to get 145 instead of 140. Then I would think that the party that should have paid more, the buyer, should then pay for the cost of deed of correction, which by the way is $50 now. You know, I don't think a closing agent would probably charge. I can't speak to that. You know, if they charge an additional deed preparation, that could be up to like maybe $200. But I don't think that's probably going to be the case. I think it's more of a recording issue, which now it's not 17 anymore. It's going to be 50. So I think that should be on the person that is paying the extra money, whether it be seller or buyer. That would be my argument, and maybe the closing agent gets stuck with it. Gets stuck with a lot of things. Okay, so with that said, let's turn to page 2. Something else that survives closing there is, of course, fraud. I think this already did anyway. They have a claim for it. That's one of those where it's fine to add this provision to. It was safe, not a lot of debate there. Lines 96 through 98 in regards to prorations. Again, I think that's a gimme. I think that makes sense for it to survive closing, and the buyer and seller would work it out on their own in regards to any adjustments that need to be made. Again, not altering the validity of that title transfer, the validity of your closing, but allowing for the parties to make things right as it was agreed to in the contract. Now, another important change, line 107.
That was a good one. Oh, sorry, go
Oh,
ahead.
you like 107?
I do, cause, yeah.
Yeah, so this makes it very
Clarifies,
clear
yeah.
that when it's up to the buyer to get the home warranty, you're repping the seller. When it's up to the buyer, hey, look, I'm checking this. I don't care if you waive it or you reserve the right, but let me be clear, my client is not purchasing the home warranty. That burden is on you, okay? It's all on you, and it's at your own discretion and expense, as that sentence calls for. Now, 108 and 109 as it relates to that, this is very important. They're allowing the home warranty to survive closing, which I think makes sense. That was certainly one of the most sought after provisions to have that apply to. However, they're limiting the seller's liability for not calling in the home warranty if they fail to, or maybe if you're the list agent, you forgot to do that on their behalf if you were supposed to. They're limiting it to the cost of the warranty. Let me give you an example. Failed to call in the home warranty, it was a seller's obligation in the contract. The furnace breaks 2 days later. Are you obligated to the cost of the furnace as the seller? No. You're going to be
Not as
obligated.
this.
I mean, that's huge. But I will say that that doesn't change in regards to maybe a claim for misrepresentation or disclosure. So if somehow they could tie that back to one that would survive closing, like fraud, misrepresentation, disclosure issue, maybe that condition, they had some problems with the furnace, they never disclosed, you may still be able to backdoor in through another claim the cost of that new furnace. But as it relates to the home warranty, no, it's just the cost of the home warranty.
Well, you could also from your client, if they're the ones that are damaged and you were the one that was supposed to, per the contract, register the warranty, they could come after you for, lack of fiduciary responsibility. I mean, they could call the Kentucky Real Estate Commission and complain on you, and you could have an
Basically,
issue
you're in
there.
favor of furnace.
You could end up.
Get your checkbook out.
Yeah.
All right, guys, no changes on the following page. We are going to get to the next one, which is the survey contingency. How many of you guys use the survey contingency? Very few, it seems to be. I will let you know that survey contingency, they just clarify that the survey itself is at the buyer's expense, which it should be. It's their right, it's their contingency. And it just puts a shell there as far as the notification if they want to void. Otherwise, it makes it clear that contingency has been waived, no notification exists. So just giving you a heads up, if you rep the seller and you receive this buyer contingency, survey contingency filled out, just food for thought. Happy to work with you guys if you don't have one, but contact a trusted legal professional. You may want to consider countering and allowing that seller a right to cure period, okay? Let me give you an example. We have a fence that's 4 feet over. Is that going to blow up your closing? Do you really want the buyer to have a right to get out over something so minimal?
Yeah.
Maybe not. I mean, maybe you go to Lowe's and move those boards yourself. So if you're able to put in for those, especially as it relates to those minor encroachments that may be resolvable, maybe you go get a driveway easement with a neighbor, put in like a 30-day period for the seller for a right to cure before they just have an automatic right to void. Okay, but work with your trusted legal professional to get some stock language if you find yourself in that situation.
Are
Makes
you
sense?
able to send something over for us to use?
Yeah,
Me
mine
too.
was good.
Yeah, I'd love to. Okay. Data possession, that's one of those gimmies, right? It's going to survive closing. Condition as well, and that's something that had in the past, and walkthrough, leases, all of those are gimmies. They're obvious. I don't think there's any discussion on those points. So we're going to move to the next page. Smoke detector. I see a lot of violations here. A lot. I see y'all at my office with smoke detectors. I do. It's technically not a duty one that you can transfer under the Jefferson County ordinance, Metro ordinance, and it is supposed to be done prior to closing. But, I put blinders on. I know that smoke detector ordinance has to be signed. That affidavit has to be signed in order to get commissions. I get it.
Bringing a smoke detector to closing doesn't mean that you didn't comply. It could be, you could be giving them an extra one. You could just like, you could just like carrying.
Fantastic. Risk of loss, excellent example there as far as it surviving closing. I think it would have anyway, but let me give you an example. Let's say a minor tornado had hit and it maybe changed the structure of the front porch on a home, okay? Maybe it wasn't realized at the walkthrough, but you know, they go back and they check the weather information. They were able to track that there was a touchdown right there, and post-closing there were some issues relative to that. Go ahead, Jay.
Hail damage.
Hail damage,
You
yeah.
know, you have a storm. You didn't realize there was hail. Nobody did. You close because you didn't get on the roof. All of a sudden, a month later, you get a leak. You realize that there was an issue with the roof.
I think it also
You
goes
have to
back
be
to
able
the
to
condition of possession too, but you know, it's fine to put it in here with risk of loss, kinda all goes together, if you will. Next page for me. Alright, so mediation arbitration survives closing, obviously. Many times we're mediating and arbitrating post-closing, please.
How would you document hail? Just go back to the
Weather
weather
report.
report?
They can pinpoint it. You need to ask this guy. He can
Yeah.
tell you exactly how they pinpoint hail.
The roofers have a.
But,
online system.
Yeah, there's literally they can get you down to like an address,
Yeah.
whether this address got hail or not on a specific day.
Oh yeah,
It's like it's pretty crazy.
technology.
So before we move on, I wanna make sure that I understand, cause I feel like I don't. So you're saying that if there was hail 2 weeks ago, after the closing, the roof leaks, the seller is still liable?
If they can determine that the leak was as a result of the hail that occurred prior to the buyer's ownership.
Well, how does that work with, because now they've canceled their insurance?
And they can't file a claim. Like,
Well,
after the fact,
Yeah, you can.
While it
I think
was
the insurance
insured,
company's
while
still
it
on
was
the hook.
insured.
The insurance company is still on the hook because
The insurance company's
it's
still on the
have
hook.
while the policy
During
was in
their
place.
period.
During
the
their
date
period.
of loss. was
Now,
the
if they
policy.
had canceled their insurance before closing, before the hailstorm happened,
The
But they
gray
should do that
area is
because the risk
proving
of
that the
loss
hail is
paragraph.
what's causing the leak.
Yeah.
That's the problem.
what ends up here's what ends up happening. A roofer tells you that it does. The more reputable the roofer, the better. And then you take it to the insurance company and they decide whether they want to fight it or not.
And the buyer's insurance probably wouldn't cover it if they realized, hey, we had a big hailstorm 2 weeks ago, that should be on the prior
On the other
homeowner's
dime.
insurance.
Or they subrogate, and a lot of times your insurance, if they like you, they will pay, and then they'll go sue the other insurance company and get their bills paid.
I love it when we use legal terms like subrogation.
Yeah.
You learn that kind of stuff when you have
Everybody
apartment
know what
buildings that
that
burn down,
means.
right?
Does everyone know what that means? Just.
Of course.
What?
Yeah,
I know.
definitely. I say it a lot.
Well, I mean.
What, subrogate?
I picked up when he said.
You don't really need to know. I mean, subrogate's not something you're going to run into. Subrogate basically is a legal process where one party sues another party to recoup damages that they've taken care of because it was in their interest to take care of them. So, like, your insurance company has a vested interest in the condition of your property. So rather than let the roof continue to leak while, people fight over who should pay for it, they just pay for it. Okay, and then when it's determined that it was the other company's fault, they sue them to get the money back. That's essentially.
Obviously.
Or the tenant, that's fine.
Yeah, clearly.
Clearly. Okay, guys, I'm going to skip paragraph 27 because we're still on this surviving closing bit. And I'm going to jump to line 324. This is the only part that scares me a little bit. It's huge because you need to be careful what you write in here or what is written in here. Anytime you kind of give free authorship to somebody, that scares me. We never know what somebody's going to write in. And I can't give you hard, fast examples because anything essentially could be written in other provisions. We just want to make sure that we're being cognizant of the fact that what's written in there will also survive closing and the delivery of the deed. So if it is not the case, and I would imagine that 9 times out of 10 you're going to want to take a hard, fast look at it if you rep the seller. You want to just be careful, be cautious, okay, of what you accept and also what you write in. Okay.
Anything that comes to mind that really scares you, we need to.
No, I mean not offhand. I think it just depends on which party you represent and what type of provision is written in. And it may not even apply, but just think about it. And if you have concerns about what's written in, contact your trusted legal professional and say, hey, this is one of those where it's in the other provisions survives closing. Do I need to worry about that? Is that okay? My seller accepts it. Is that should I counter that? And I want to be very clear about this. I think that despite the school of thought that you're in favor of, I think that it's in our best interest to kind of keep this as it's written, and especially as it relates to the other provisions. You know, some folks may be like, oh, I don't like that surviving the closing. Every time I write an offer, I'm gonna strike that, or every time I receive one, I'm gonna counter in general, you know, every seller I have. This contract has been vetted and approved by attorneys, by your board, your E&O is gonna cover you. So I think that's important. I think we should go with it, even if we don't necessarily agree with, you know, all of it. This is here, you know, to protect you. I think if you start advising your seller or filling this out rote on every single transaction, you may find yourself in trouble. Does that make sense? So I think we should go with this. We shouldn't be advising people to strike it every single time. Not to say that every once in a while on that other provision something concerns us, okay? But just largely as a matter of practice, I would caution you against routinely striking that, okay? Now, paragraph 31, survival clause. The first sentence in there is your catch-all. So that's going to be, in addition to these provisions herein, which by their terms are to survive the closing and delivery of deed, any provision herein which by its terms is required to be performed after closing and delivery of the deed shall also survive the closing and delivery of deed. It's a catch-all. If it was supposed to happen post-closing, then it's going to survive. Let me give you a perfect example. Repair requests, okay? I mean, how many times you've been in that repair couldn't get made till after closing? Your folks still want to go ahead and close, okay? If it's not done in a workmanlike manner, or if it's not done correctly, whatever the case may be, you'll still have a claim. It's easy to refer to, hey, you know, under paragraph 31, we're allowed to go back, you have to make this right. Although many times in a repair request, we have that language in there anyway, okay? But that's an obvious example. Now, the second sentence is very important. It's going to be your cap, okay? So they're going to cap that for 12 months. So largely with the survival and of the closing, a seller is going to be at risk, right? They're going to have to kind of look over their shoulder. But for how long do they have to worry about a claim coming back under this provision? 12 months. Why do we use 12 months? Does anybody know?
365 days for mediation.
No, but
Statute of limitations on, contractual disputes.
your professional liability. So that's 12 months.
Okay.
So what we didn't want to do is cap it at 6 months, and then they can't recover against the seller. Who are they going to look towards?
Yeah.
The agent.
Yeah.
We didn't want that, so that's why we settled on 12 months and thought it was a really nice cap. Does that make sense?
Yeah.
So, how do you explain this whole concept to your client? I don't want you to have a legal conversation with them. If they would like to have one, refer them to a trusted legal professional. You don't need to get in the weeds on the merger doctrine and how court may interpret it and blah, blah, blah. I think the best way to handle it is just kind of generically, hey, look, if they have questions, you go over the contract as to what it means. If you promise to do something, you're going to do it, right? That makes sense. That's easy to explain to folks. It's easy to understand. It's going to be capped there at 12 months. And any further discussions that they have, you may want to wrap in an attorney. Would you agree with that, Jay?
Yes. Yeah, can I go back to 27?
Please.
So you and I had a conversation about educating the agents to be very careful about binding language in electronic communication.
Right, so now we're going to talk about paragraph 27. So I'm not sure if anything's been distributed yet, and it hasn't. Okay, so essentially,
Maybe they might have what came out in the GLAR emails.
sure.
I
So
think we
the
should-
GLAR Weekly Direct, I think it actually came out twice, but it came over the holidays. So a lot of people probably aren't maybe checking your email or reading out your mailers or newsletters during that time frame. But I did resend it to Lana, so she has that. If you all want to take a look at that, but
We'll get it in workplace.
Senate Bill 114 changed things. I think that they were trying to go after some changes to the remote online notarization, and as a result, it altered what we would normally reference the statute of frauds, right? So if we have a contract for the sale of real estate, it's got to be in writing. Well, now electronic communications can change that, and you can still bind someone under a certain set of circumstances. And it may not just be one writing. They may look at the set of circumstances, the intent, multiple writings that may exist in determining whether or not that does in fact bind them to a real estate transaction. But KREC and GLAR would like you to use a disclaimer that's contained in that newsletter. I have it here, okay? You're going to include it in your emails and your signature line and your text. Now, I'm told, I know it's not sexy, I'm told that the Apple phone won't let you put that as a signature line or anything to add in the text, but there's an app for that. There's an app for everything. You guys are so tech savvy here, you can kind of get into that. But it says, if I may, the disclaimer, the sender of this email/text does not intend to conduct a real estate transaction electronically. And all electronic communications involving this transaction are not intended to create an electronic record. The inclusion of my name or contact information, because how many guys have that in your signature block? Everyone. Probably your beautiful picture too. Is not intended as an electronic signature, which could bind your client. Any binding agreement must be signed by the clients via an electronic system or program such as AuthentiSign or DocuSign. That's it. I know it's a mouthful. But I know, brokerages, you may have already seen this.
Is this every single text, or is
I'm
this,
not texting
can we send it once and it becomes?
I'm not
Yeah.
texting anymore.
And
Okay.
in addition
Alright.
to having that disclaimer contained in your signature blocks, they advise you to never use terms like offer and accept
Yeah.
in your electronic communications. Okay, so the fear is that you unintentionally
Bind your client to a
bind
contract.
your client to a contract or a change to the contract. And
So if you read section 27, it's a little confusing because when I first read it, I thought it was saying something different than what Cora's telling you right now. But I've talked about this with several of you already, but it is extremely important. Okay, I don't know where I stand on this. Cora knows I don't like it. I will absolutely distribute this language for inclusion in your email signature. I don't see how you send, 150 word disclaimer in a text message.
it's 99.
Is it 99 words? Did you count it?
Just text them and say, call me, I need to have a conversation.
Or
Yeah,
check
that-
your email.
Can you just do it in the beginning, like when
Every
you first start
agent's
working
hiring.
with
Call
somebody,
me, dude.
you just text them right in the beginning?
I don't know that
Corey
suffices.
shook her head
Can-
no. She said
Can
number
you
one.
add like another
She's
11
counting
words
words.
that says?
Are you really counting them? She's counting.
Counting.
Here's the point.
What if you
Verbal.
I'm not going to tell you have to include
Anybody
that in your
guess?
172.
88.
70.
Anyway,
67.
too many.
million.
Too many is the answer. I'm not going to tell you have to put that in every text message. I'm not going to do it. What?
But the KREC and law recommends that you do.
Can't even tweet it. It's too many words.
Just
Too many characters to
know
tweet.
This
What's
is
for
a
dinner, by the way?
for all of us talking to other
This is not
agents.
Yes.
more
Right.
Yes.
And not texting everybody.
Yes,
Maybe
communication.
this
I
The
have a
flashing
question.
way.
communicate.
I have a question. Let's say we're negotiating potentially verbally with another agent about, how can we get this offer accepted? What do we need to do? If we text that back to our buyer or seller and say, hey, they would probably be willing to take $400,000 for the house, is that potentially without our disclaimer at the end? Is that potentially
No,
opening up?
it's not as it relates to your client. You can have
Okay.
those types of communications. You're worried about binding your client on the other side.
Okay.
Yeah, I had a situation on Wednesday night, 'cause we talked about it on Wednesday, that I would have normally done that, but like a
But
few
you
hours
might twice.
before we talked about it, so
Yeah.
I put in an offer. They're at the 11th hour, they get a second offer, of course, and the house going on
Yeah.
forever. And we had about an hour and a half to send a response. Well, I was out playing volleyball, so I had to get done. I talked to my client, and before he was gonna sign, I was getting ready to text her because I think the other offer was really good. So they were thinking about they were going to take it because they were getting close on their deadline. So to let the agent know to hold on a second, I almost texted them, hey, look, we're going to go up to 170. We're signing now. My client did sign, but in my head I thought, well, if he didn't,
Did I just
then
bind
I'd be
it?
Did I just bind you?
exactly. So that's the situation that I
That's a
typically
bit-
would be like, hey, we're going to do 170. I'll get it to you soon.
Can I?
I'm gonna get 170.
Take the
Real quick, I want to say something just in practice. What you need to understand is that, this is going to manifest a lot of different ways, and you can't possibly understand all, like, the different variables that you could encounter. I think it's a time that we should really reflect on the actual language we're using and how it changes when it becomes in writing versus verbal. Okay, you should obviously be careful with the things you say verbally, but you should be more careful with the words you write in text or email or any sort of written communication because of the lack of context that is able to be read when you eliminate body language and tone and all the things, right? So the way that this is, I think, going to manifest is
Scott, in your circumstance, it might have been convenient in this particular situation to be able to bind them with with written communication via text message.
Maybe that's better.
Maybe it is, but let me tell you what, it's not going to go that way. If it is convenient for them to claim that you did not bind them, that's how it's going to go. Okay? If it is convenient for them to claim you did bind them, that's how it's going to go. It's going to be nothing but a nuisance for you either way to adopt these practices. What we're here to do is tell you how to protect yourself from finding you or your client in an unfortunate position. Understand? Because like nobody's gonna take your similar interpretation to their own disadvantage. Does that make sense?
So like if we said that they sent a counter in the midst of all this, and
you said we accept,
and then between by the time
they get another
offer,
offer,
and they say, oh,
we accept that one, you're never going to be able to enforce your text. Never. I'm telling you, Cora won't agree with me. Well, she may agree with me, but she won't say it. You won't be able. I'm telling you, you won't be able to enforce that. Okay.
So if we can't enforce it, is there a strong possibility the other side can't enforce on this?
Maybe not, but they can make your life difficult.
But on the backside, the situation Scott described right then, it would have been, it very well could have been very much better for him to go ahead and say, we're going to go to 170, do not sign that other offer. And so what if we bound it, that kept them from signing the other one so
but
that you had
then
time to
you
get
gotta
your
enforce it on the other side. And, I mean, like
your ability.
Yeah, but the only thing I needed to do is just tell that agent, don't sign that
Well,
one because I'm going to give you this.
Okay, and Ryan makes a good point, okay? I'm not going to tell you to go out and start binding to your, trying to bind your clients to contracts via text message. I'm not going to tell you to do that. There's too many variables that could get you in trouble there.
You could potentially have that buyer send you a text that says do it.
Yeah,
It may or may not even be binding. I mean, just because you say, we accept it 170, yeah. I accept your offer. I mean, they're still going to look at multiple writings and set of circumstances and whatnot. And so I hate to dog my own profession, but I mean, this is where the litigators are loving it on the closing survival and the and this matter as to whether or not it was bound by electronic means. And by the way, texts and emails, it's not just that. Facebook. Any kind of like social media, direct messaging. There can be other forms of electronic communications we haven't touched on.
Yeah.
I have a question though about the verbiage. Like
Yes.
if you say, I think my client will take 170, I mean.
Did you or didn't you? I don't know. We accept. I mean, that couldn't be much more, bind it clearer and cut than that, but I would still see somebody argue it.
I got a question for Cora on this because we talked about it. How is that possible? Because I can't sign an offer for my client. I can't just write up a 170, sign it, and send it over.
But you can't accept verbally
which
and
is
over
like,
text.
my client didn't send that text. I can't sign anything for my client, but yet I get power of attorney to send a text and then sign. It doesn't make sense to me.
You are their agent. You're their fiduciary, so you can act on their behalf. Yes, I understand what you're saying. I can't sign a contract for them without like a power of attorney. But it's just the day and the age that we're in, and it makes sense. But we just have to be careful because what was once informal methods of communication can now be binding. And I will send you the information so that you can read it as to why that is the case, as to how your signature, being your name and stuff at the bottom of the email could be an electronic signature, so on and so forth, and how they consented because they used DocuSign early on to use an electronic process, so on and so forth. So I'll send you that information. It's a lovely read if you can't sleep.
Okay, so a couple of things that I want to highlight that I say often and they can't be said enough that are not foolproof but very good ways to limit your liability with respect to anything is work with people you know, work with people you like, work with people you trust, service providers, clients, etc., all around. Okay, you're going to run into less of these problems because of that than you are by doing something different.
Yeah,
Understanding when you're in that other, look, we're all building businesses. We all work with an unsavory client every once in a while, or maybe more often. But knowing the situation you're in, Scott, and when you can do one thing versus another is extremely important.
Here's the problem, though, and I think by and large most of us work with people we know, like, and trust. I'm sure Scott's client he worked with was probably one of those situations. It's probably more few and far between that the issue is going to be with you and your client. It's going to be with the other agent.
Yeah, of course.
Because you can't help the other agent you work with, and how many crappy ones do we work with every day, right? So that's where I see this thing blowing up, is with the other side. I guess the good side to that is, I mean, a private conversation between you and your client, yes, it matters what you say, but then it's on the other party to get that information and prove it. And if you're not sending it, well, a private conversation is still a private conversation, but the problem is the communication you have with the other side. And that's where I think this gets...
I agree.
Because people aren't going to understand this.
Because we can't even get people to enforce deadlines.
Right. You're not going to get, like, you're going to get agents that think they understand this, and they're going to try to, like, it's going to make... Multiple offers is going to make our life hell with this right now.
But it all comes down to what we normally say. Even if that happens and someone says, "Oh, well, you were under contract based on your text message," it still goes back to who's going to be the bigger a-hole.
Right.
They have to do something to enforce that. Are they going to go through all of the trouble to hire an attorney to make you
Not
do
when
whatever?
you can get a termite inspection for $50.
Yep.
If you're the buyer,
That's what I told me. Black Diamond will be there tomorrow.
It's the
I'm going to get that release draft.
But you know,
Because even if Scott bound his clients
Yeah, I would
to a
have-
contract,
He can
and
still
they
get
said,
them out.
"We don't want this," Scott can say, "You know what? I got you.
yeah.
$50 I paid
But
out."
the issue is when you're on the other side of the contract, the sellers can't get out. So if you're representing the seller and that happens, the buyer, yes, we're out of here. But
Sure.
the seller, I mean, you can be an a-hole on the inspections, but like the buyer still's like, yeah, you'll take it out.
How does it go bad for a seller though? Because if you text the seller and you say, "We're going to go to 170, don't sign the other contract," then you never send the 170 and they can't bind you to it. The offer that expired, what are the odds that if they call that agent 2 hours later and say, "Hey, we did want to accept your contract, can we just extend that time frame for 2 hours?" Like, what's the big deal for the seller either? So I mean, I don't see how anybody. Everybody's like all that. I don't even see how.
if I may, I think you raised an excellent point, because I think largely we're looking at this from the standpoint of don't find yourself in that situation, don't get yourself in trouble, you know, and binding your client unintentionally. Use this language, don't use offer and accept. But what if you have an agent on the other side that's trying to trap you? What if you have somebody really savvy and they're, you know, trying to text with you and you're in a hurry and they want to bind you, they're trying to pull one over on you, and I'm like, ooh, I never really thought about it that way, but I guess people are going to read up on this and just like they would anything else and maybe try to take advantage, and that's unfortunate.
Well, I've been, to Tracy's point earlier, I've been so thankful to have, you know, text records to be able to go back and look at what was said and what wasn't said, because that way, like, it's there in black and white, like, nope, I sent this to you at this time, and I just, especially working with agents that we don't know, we can't control who's on the other side of the transaction, like, having it in writing over just talking, because then you can say, he said, she said.
But now you might not want to do that.
Exactly, and that's what I'm saying, That's
Well,
especially in a multiple offer situation.
You need to be much more careful about how you speak, and it's just another recognition of what we've been saying for a long time. What you say is important. Exactly how you say it is important. In writing, verbally, doesn't matter. Okay, so you need your language has always been completely on purpose. If it's not on purpose, then you're not doing your job. Every word you speak, every word you write matters. So just continually be more and more careful. That's what you have. Look, you're not going to send a 67-word disclaimer to a client like when you're just not, because you're not going to want to seem like an idiot who they don't want to work with. I'm sorry. Nobody's going to do that. Nobody's going to do it. I know you have to say it. Nobody's going to do it. Every office you talk to is sitting there going, what? Like, not doing that. I'm not doing it. I can say it. I'm on camera. I'll say it. I'm not doing it.
However, if you save it as a macro in your phone to type in with text replacement, you might send it to another agent when you say, hey,
that's not a bad idea.
If you all will treat the termites, I think we'll go ahead and move forward.
Drop it in there.
And then drop that bomb.
Maybe when you're texting agents, I don't know.
You can put a thing on there where they got to scroll through and check the bottom.
Oh yeah, like the Apple terms of service. Yeah.
I think it's the exact same. What you said about the contract is just like, if you say you're gonna do something, and just do it. And
Do
then
it.
it doesn't matter what you texted because
At the
you did
root of
anyway.
everything, buyers want to buy and sellers want to sell, and agents want to get paid.
And you're never going to be able to fully avoid, certain circumstances. I mean,
Yeah.
we live in a litigious society. So if you're going to get sued, you're going to get sued. And I
Yeah.
hate to say that.
Yeah, this
but
just made it a lot easier though.
Yeah.
And,
Take it
yeah.
like 10%
I mean,
of their paycheck
we are
to pay for
really
legal
good at
fees.
arguing. That's what we went to school for. So,
You know-
I mean, attorneys just, that's
You know
what
your
they do.
mediator and your arbitrator and your judge
Too many.
that haven't weighed in on this yet, the mediators probably are aware of this, really aware of it, and they probably have opinions. And like, court can't roll her eyes about this stuff sitting in front of you, but she might if you got her in a different set of circumstances. The point is they bring their own biases to those situations, and if they think this is stupid and you're the one that's getting the shaft because of it, that's gonna play a role in here.
But I
It's-
don't want
it's
you guys
still
to be
up to
nervous about
interpretation.
using this contract.
Yeah, don't be nervous.
Yeah.
It's like me saying
That'd be
okay,
crazy.
cool
It's
to
totally
someone
not.
saying they'll take
Okay, cool.
165. I'm sure
Done. Exactly.
Well, looking
But you
at,
said
you
okay,
know,
cool with the
yeah,
thumbs
right.
up emoji. Okay, cool. You bind your client with emojis.
Yeah.
Here you put 3 smiley faces. So.
Yeah.
Right.
All right. Hey, let's keep it moving, guys. We've got 20 minutes, and we've got
Real quick,
a lot more stuff to cover.
contingency of sale form, real quickly, I think that's the other major one I think Jay would agree with. Guys, contingency of sale form that's rotating around, again, give me, I only made 15 copies, so, on this form, which I think is also available, maybe not through Outlook that you referenced, but, time is of the essence in regards to this entire form, so I wanna make sure you understand that, everybody is familiar with that concept. I think the easy way to break down this form is contingency of sale, release of contingency of sale, and contingency of closing. So there's 3 major sections to that form, okay? So contingency of sale. So that very first line, if you're looking at 10 and 11 there, that's your deadline. So if this contingency of sale is not released by the buyer on X date, okay, then the contract shall become null and void unless, okay, and it gives you that time frame. Now it also mentions 12 and 13. If the buyer's closed on the property, they shall notify within 2 days post-closing that the contingency of sale and closing is released, okay? So that's kind of a must on that one. But on your deadline above, do you mind sharing your example that we discussed?
Yeah, I was hoping you were going to get into this today. So I learned something new this week. I have a listing in Shelbyville that is under contract contingent upon sale and closing of the buyer's property. The buyer got an offer. It took them longer, some context is it took them longer to sell than they had hoped. So when they got an offer, they were eager to get it done because they really want our listing. When they did that, they negotiated. This is not the root of the problem, but it has a big effect on it. Their buyer wanted a 45 to 60 day closing window. Our contract has a 30 to 45 day window. Apparently, after research, come to find out that was like a sticking point, like a non-negotiable for their buyer. So they went ahead and accepted an offer with a 45 to 60 day window, and I've got a 30 to 45 day window. Follow? Kind of unfortunate. What this caused our buyer to do is to not release their sale contingency. And though they're going ahead and proceeding with their inspection, none of their deadlines commence until release of the sale contingency. Now, a little more piece of context. They're actually neighbors of the listing, and they know my seller, and they actually sent over an offer before the property hit the MLS, and my seller really wanted to sell to them because they know them. Okay, and they wrote us a full price offer. It was a really solid deal. So we really didn't go to market, but we haven't gotten a backup yet. We haven't gotten an offer to release that contingency. So we have some incentive to make this work. But they did not release their sale contingency, and it was my understanding that upon sale, the sale contingency is to be released.
It makes sense, right?
And I think it makes total sense. I've never seen it done this way, but apparently, unbeknownst to myself and the way I've always known it and done things, the prior form, I don't know what changes here, if anything does, so it's the same on this form. You can actually you can choose as the buyer not to release your sale contingency. You can sit on it for the balance of your contingency period.
Correct.
Just through inspections.
Don't most people
No.
do that through
But-
inspections anyway?
But
so.
it is a correct,
Yeah,
and it is a
I've always
double-edged
done that.
sword because those timeframes don't start ticking, and certainly your right can still be triggered.
It depends on how you negotiate it up front, okay? And I do it differently when I write a contingent deal, and I think I'm pretty sure I've taught the team to do it a similar way. But yeah, they just didn't release it, even though their house was sold. Well, now my seller's in a really interesting position because they literally have no power to change the circumstances because the buyer could technically sit on this for like another 30 days.
The buyer's really only trying to buy 2 weeks, though, right?
I think that is what they're actually trying to accomplish, but what they could decide to do
Yeah,
is wait
run
30
it out.
days. My client's already bought another house, is already getting ready to start making double mortgage payments. Now he has his house sold, and these people could sit on it, and then
Well, really, they could wait, what, 62 days, right?
they
If
could
got
wait a
it
long
until-
time. Well, they could wait until the end of their contingency period to release,
Right.
Yeah.
and then start the clock on the 30 to 45.
Yeah.
So when their house was sold essentially 30 days before, they
Yeah.
could turn this into an extra 75-day process.
I get your point, but I think to me it sounds like they're also trying to do right by your seller and not give them false hope that they're going to be able to close in 30 to 45 days when they know they're going to need 45 to 60. You know what I'm saying?
What I think,
I can see it from their side too,
What-
unless they try to push it out further than that, and then yes.
I can understand the convenience of not releasing a sale contingency. And Tracy and I had a deal before she was here where it was a contingency deal and the inspection killed it, and we had to go back to market and sell again.
Yeah.
Okay, I sold one of her listings contingent upon sale of my client who was under their house went under contract, and then the inspection killed it, and we had dropped our sale contingency, and we had to put the contingency back on.
It worked out, I didn't even tell my seller all that happened.
Well, I sold the listing.
But you know just as well as I do, they could have released that contingency, Jay, and then not been able to close for an extra 2 weeks and say, well, we just can't close.
I think absolutely.
I think
but
I think they're
all
trying to
my
set the right
seller
precedent.
agreed to,
In good faith.
all my seller agreed to was one shot. My seller didn't agree to you being able to sell the house twice. My seller didn't agree, to sit idly and wait. My argument is, and I will make the argument if it stays the same, there is no point in a sale contingency. There should only be a closing contingency if the buyer is able to sit on the sale contingency for the duration of the entire addendum, the duration of the entire agreement. There's no point because look, if you don't close, you can't close. If you don't close the sale, you can't close the purchase. There's no point in having a sale contingency unless it is to be released immediately upon sale. Okay, maybe you can make an argument for getting through inspections, maybe, but I still don't think that the seller agreed to that. I think the seller agreed to let you sell the house once. I think it speaks to the validity of the transaction at large if you can't get your first deal done. Because that tells me that your house that I'm contingent upon you selling may not be viable enough to get my transaction that I care about finished.
But if you're on the other side and you're playing that game, I would caution you because it is a double-edged sword. And what the seller could then do is go, all right, well, I'm going to, put myself in a situation where I'm going to stay in my home for 75 days. So if the buyer plays the game, purposefully delays, and then gets into that 30 to 45-day window, wants to close earlier, and the seller's like, no, I'm good. And meanwhile, their house did close because they didn't release their sale.
And you got nowhere to go. Now
They
you're
got nowhere to go.
Now you're homeless. You can't force me to close for another 45.
Wow.
Okay, so it's really weird. I think what should have happened is our buyer should have been forced to negotiate their sale concurrent with our deadline and release the contingency same day. I think
But
that's what they
sometimes
should have had
that
to do.
can't happen, and you know
Well,
that.
and here's what they say. They pick up the phone and say, "Hey Jay, we've got an offer. We can release your sale contingency and get this thing moving, but we can't get our buyer to close in 30 to 45. We need 45 to 60. Can you give us an extension?" To which my seller would say, "Absolutely. Let's do it."
But what you need to do is consider that as it relates to line 10 and 11 here. So if you represent the seller, that's going to be the deadline that's very important. What time frame is placed into that box there? Because if that's not met, the contract is automatically null and void. That is a change on this form, okay? So you may want to take that into consideration.
Yeah.
That they may not release the contingency of sale right away, but hey, they have up until this date.
So here's a question: What if they sell the house and don't release the contingency? Because this doesn't say they have to release the contingency
Are you
if they're
saying
sold.
they close the house?
No, I'm saying they put their house under contract and then they wait until this expires,
And then they're
And the
out because
contract's
they
dead.
found
and the
another house.
contract's dead. So they get a
Unless
free.
they're
So they
right
got
on
they got
that.
a free out. It's stupid. They got a free out on the contract.
Yeah, they don't. It's like arguably they still do under inspections and haven't started.
I guess you're right. I guess you're right.
So-
Okay.
Yeah,
Anyway, all right.
One thing
Sorry,
really
Terry.
quick, because
Shouldn't hold an
I
argument.
know
How many people we got right this? I
some
can't.
things that are obvious to a lot of agents, to newer agents may not. I wanna make sure everyone in this room does understand what time of the essence actually means.
Yeah.
Does everyone understand? Jennifer, my team, do y'all know? It's drop dead.
Done.
We write that
Over.
in there. If there is no,
Reasonable time
it's up
thereafter.
to interpretation. That all goes away. I just wanna make sure everyone.
Something else too. You can change any of this. Strike through, write on, draft an addendum. What's that? Give
It's
legal,
illegal.
get legal advice before you practice law. Don't practice law.
E&O's not gonna cover us.
Yeah.
Striking.
Don't practice law. You know.
All
Don't
right,
practice
if I may, just go through the rest of the form briefly. Lines 14 through 17. Now, one way, let's say you do have that buyer that's sitting on that contingency of sale. They do have it under contract. What would be a way, too, that they're going to find themselves in trouble is that it must be actively marketed. What is that? Arguably, I think even pending status may be actively marketed because it is on the MLS. Certainly active under contract would fit that bill. But if they took it off the market for some reason, I don't know if it's a private deal or whatever, then you could find yourself in a situation, hey, you must release, you're not actively marketing it. It's not on the MLS anymore. But that may be few
You
and
could
far
argue a
between.
sign of the
What
yard
about
is actively marketing.
Pardon?
You could.
You could argue a sign of the yard is actively
Absolutely, you
marketing.
could.
What about office exclusive?
You could. It's just an argument.
I think that's a lot weaker though. But
I'm sure
you
it
know,
is a
I'd love
lot
to be
weaker.
on the
Just
other
to
side.
sign in the yard is really
Yeah.
weak. But
Right.
I mean,
But at least that's to the general public, whereas an office exclusive is not.
yeah.
So,
But it states that it's gotta be active, it's gotta be,
active
With an
marketing
agent
on
on
the
the
MLS.
Yeah, so
on
you
the
can't
MLS.
just
Okay, so
sign
does
it.
that
Yeah,
mean
you
you
can
can?
sign off
Yeah,
exclusive
exactly,
on
good
Zillow.
point.
Yeah, you can. But
Yeah.
this
But
form
that
actually
one
does
does say
say
MLS.
MLS.
It does say
Is that a
MLS.
new addition?
So that eliminates that argument.
Oh, nice.
The second major concept here, release of contingency of sale. Okay, so first sentence, buyer may release this contingency of sale on or before the deadline that I referenced on line 10 and 11 with written notice to the seller. And then there, of course, is the same way that you can trigger that right of refusal, 48 hours, 24 hours, whatever you guys are used to using there. So how do you release the contingency of sale? Well, the buyer can release on their own, or if the seller notifies them that they've triggered that right, then you must do A or B. At that point, A is exactly what it used to be. B has been modified a little bit, and the way it's been modified is you must provide written evidence, and it says in there what that evidence shall include, okay, which is pretty reasonable, I think.
Official
makes
letter
sense.
from a licensed lender.
You basically have to show the documentation, the buyer's ability to purchase, okay? Right now, before, there was no documentation
And that-
requirement, but there is with this form.
Okay.
So that's the major difference, okay? Line 31 through 34, if one of the parties refuses to sign mutual release, then the contract is void anyway. Your deadlines, we beat that horse. The third major concept on this page is the contingency of closing. So obviously if you do release the contingency of sale, you still have that contingency of closing, unless of course the buyer waived it and says they can perform regardless if not the 48-hour right was triggered. So this is important. The grace period, so line 43 there, I just want to caution you in writing that grace period. You may put 5 to 7 days, you know, I think 3 or 4 may be unreasonable because if you have a lender that can't get it together, you don't want this to be null and void. You want to make sure that the grace period that's allowed for that contingency of sale deadline is going to favor your buyer if you're representing them right here.
No, I'm sorry.
Okay? All right.
Okay, hold on.
So there's a grace period. Wait,
Yeah, I'm.
you're extending the contract now
Mhm.
with a contingency addendum up front.
So if despite the good faith efforts of the buyer to close on buyer's property, the closing on buyer's property does not occur within blank days of the closing date set forth in the attached contract. So rather than it being a time is of the essence on the closing date, we've got a grace period. Make sense?
So what should we make that?
Well, hold on. Doesn't that change the terms though of the original contract with regards to closing?
Doesn't the inclusion
Because if you write 0 days in there, then it's time is of the essence with your original closing.
Exactly.
and
So how can
but
this
no,
supersede
Jeremy,
the other contract?
it's time is of the essence regardless of what you write in there. Because if you write 5 in there, then it's time is of the essence with respect to 5 days past closing.
Right, but he's saying if you write 0, then it's, yeah.
It's time is of the essence on the original terms of the contract.
Right,
Still
but-
allows for a
But
grace
this
period.
basically
With
just
the new
makes
contract, time is not of
deadline.
the essence with closing, right? No.
No.
So what I'm saying is this is saying that now time is of the essence with regard to closing in your original contract.
Yeah.
How can this supersede this? I don't like
Yeah,
it.
I don't like that either.
I don't like it.
What's a mutually
So
agreed
now
upon?
anytime you have a contingency,
You have
time is of the essence with regard to closing.
unless you
period.
strike
That's why
this
you want to
clause.
put your grace period in.
Yeah, but it's still,
But it's still
time of the essence.
at the
Because
end
even
of the
with a 5-day
Right.
grace period,
But
it's time of the
but it's
essence.
the same difference if you think the closing date and any reasonable time thereafter, let's say 5 to 7 business days. What's the
But
difference?
there
You
is
put 5 to
no-
7
But there's no
days.
time is of the essence. You can argue it in that point. Now you can't. It's time is of the essence. I don't like that at
Yeah,
all.
I don't either.
That's
Strike it.
Well, I always operate under the assumption that 10 business
You
days
extend
is reasonable
you
post
can
closing.
extend time is of the
So
essence.
I would probably, if I put
Right,
anything, I'd
it's
probably
time
put
is of the
that.
essence. So if you don't get an
Can
extension, you're done.
can I strike it?
Yeah.
Well, sure, we
Just
may
strike
want
it.
to discuss that based on your set of circumstances and, your individual client. We never want to do anything rote, because every situation is different.
You just don't want.
may
to-
wanna
I just
consult
don't
with
understand
your
why they
legal
would make
professional.
this time is of the essence and change the terms of this contract. I don't understand that.
Yeah.
That seems like a big time oversight on their part.
So you either strike it or you better be ready to extend with an addendum
I
prior.
think that's why
because if not,
they allow for you to put a grace period in on that contingency of closing for the sale property.
14 days, but it's still a time is of the essence, though. That's the thing.
Yeah. Well, I do agree with Jeremy. I think it's an abandoning of the way that we've gone about things. Like
Well, it goes it's in direct opposition to our contract, is the thing.
Yeah.
With having time is of the essence with regards to closing. That's the thing I don't like about it.
Are you still on the forms committee?
Not this year.
I was gonna say, maybe.
But I can submit it to somebody who is.
Well, that's just.
I mean, they're not
This
going to
is
change
actually
that.
Cora's idea. So.
But if I may, good point, I will raise it to somebody on the committee, they just met yesterday, well, actually Wednesday, I think I might. Okay, so vacant land contract, for those of you who use it, the only change there was just a new paragraph 16 that was added to mirror the language of the residential sales contract, nothing to worry about. Our notification to buyer that another offer has been conditionally accepted, it's been slightly revised just to align with that contingency of sale form. Nothing to worry about. However, the notification of release of contingency of sale that Jay wishes his people would utilize, that's a new form, and so other people may have been doing it via an addendum, but it just makes it very clear cut to use this form in that scenario.
We can do it via text now, right?
You all probably had this, but the move in, move out form.
Yeah, that's
Okay. That's a new form. What is
If
that?
any of you use the rental forms from GLAR for your own properties, there's a new
Move in, move out form.
check in, check out inspection.
Yeah, and then the lease, of course, lease date was added to the top of form, not a big deal. Notification of requests and repairs and replacements, they changed the page at the footer, so nothing to worry about there. And last, the termination and release of contract, they just deleted a line for the date and time above the signatures because it was placed at the top of the page. Nothing to worry about. So my main concerns are the contingency of sale form and the contract, and hopefully I've addressed both of those with you today.
Yeah, we have. I mean, we're gonna probably not launch into a new topic though. We've had.
Oh, I can't share the term line? Come on.
Well, okay. If you can do that real quick,
I
let's do that. We'll stay away from regs today.
And I'm just gonna give you the handouts on the regs. How about that?
Okay,
You all
that's
can
fine.
read it at your
Can
leisure.
everyone do me a favor before you write an offer on this new contract? Before you write a contingency of sale and closing, can you please do me a favor and read it cover to cover before you sit in front of the client?
Yeah.
That's all I ask. You need to read it. You need to ask questions before you are sitting in front of a client, compelled to have them sign something that you don't understand. Okay?
These
Because
are the
they want
changes.
to buy a house.
If you'll take a copy and pass that down, I made this for you because I just printed out chapter 11 so you can have the revisions.
Thank you.
Jay, are you opposed to, well, I'm sure this is gonna replace the new contract, but I do happen to use this a lot.
Land contract?
No, the one we were
Contingency
talking
of sale
about.
and
If this is gonna be the one in Dotwood now, would you suggest me to put 10 days here?
I'm gonna get back to you on that. 'Cause I'm sure
She's the
Cora
old
wants to talk to me when she's not on the spot about
She's the
this
old one.
and convince me why I'm being
Tell Cora to
silly.
cover her.
But I don't like it, like Jeremy and I said.
It's fine, I would go 10 then 3. free.
We're gonna talk about it and figure out what to do, and I'll get back to you.
Quickly, if I
About
may,
this
I did want to tell you
specifically,
one
Bob,
other thing that may cause
if we
issues
have-
later in the year.
You guys
I
need
do
to hear
have
this,
a-
okay?
We have
I do have a
60 days to
handout,
close
so
on this
NPMA, National
This
Pest
is just
Management
saying
Association,
that-
has been working with NAR for the last 3 years to make revisions to the termite inspection form. They did successfully do so last year. Those guidelines are being passed around to you for some more light reading. I'm sending you all homework. Expect a full report. They actually became optional in July of last year, mandatory January 1. So you probably didn't see it last year. If you had a termite inspection since the new year, you're gonna see it. Let me tell you why and what's most important to you. Essentially, they changed some guidelines because they care about consumer protection and also a little bit more objectivity and consistency as it relates to recommendations for termite treatment. So here's where it's gonna get you. If you have a seller that's on a listing who has prior termite treatment to the home, we all know that's pretty obvious, right? Everyone's like, how am I supposed to know if there's prior termite? You're probably gonna know, right? So if that's the case, as a matter of due diligence, get documentation of that prior termite treatment. Once you get that documentation, and hopefully you get that under contract pretty quickly, give that to the termite inspector prior to the day of inspection. Because if they have that in hand, I'm told they will not make, absent a reinfestation of course, not make a recommendation for treatment. If a home has been treated, from what they can see within the last 5 years under the guidelines, prior termite treatment, if that termite inspector sees that, and nothing was given to them as evidence or documentation of that prior treatment, they will, pursuant to the guidelines, check under Section 3 and recommend termite treatment unless the homeowner can provide it. Now, at that point in time, the guidelines does not allow them to go back and revise their termite inspection, I'm being told. In fact, now then, if it's a VA or FHA, it's up to the lender's underwriter to determine if some subsequent documentation is sufficient to lift that. So what does that mean? Well, the seller could suddenly have to pay $500 or more for another termite treatment because they didn't have that documentation in advance. Best case scenario, maybe pay for a warranty, which would be less, but those are issued on a case-to-case basis. They said they're kind of going, probably in the future, more like a California standard, where you're going to see warranties if there's prior termite treatment for real estate transfers, more so. But my concern is, hey, regardless of what side you are on, if you're the seller, get that documentation lined up for prior termite treatment. If you're the buyer and that comes up, if they have FHA, VA, you don't want that to be flagged. That could be a delay in your closing. There also could be some other arguments is, even if it's not an FHA or VA, and they do mark it, suddenly then is your seller obligated to perform termite treatment because of documentation, being absent from that? So I see it maybe coming up this year. We're gonna walk our way through it. I didn't want you to be surprised by it.
Who wants to start a termite company with me?
So, right. Yeah.
So,
Oh, yes.
question.
The termite form. Sorry, I didn't mean to interrupt.
The actual, let me see if I can
It's okay if you know. I'll pull it up. My
So
concern.
the new form isn't gonna say it, okay?
Okay.
Because, it has revisions on page 2. It has revisions in signature block, but what I'm talking about, and I sent you a redacted version of one. So, let me kind of, show
Every house
you
that
here.
sells is
This is
gonna
what I'm
know
talking
you
about.
require that.
Okay, so in section 3, so you guys have, section 1 is like the property, section 2 is inspection findings. That's the one that says visible, no visible, dead insects, carpenter bee holes, visible damage to the sill plate or whatever, right? Section 3 is where they recommend treatment or don't recommend treatment. So it does say no action still.
That's correct.
Okay, so
They do not see any reinfestation. However, they did notice there was evidence of prior termite treatment. So as a result, under the new guidelines, they also checked box 2, and they say, because right now if I give you a blank form, it just says recommend action.
regardless of active infestation regardless of whether there is no active infestation, you probably heard of shelter tubes triggering treatment. Okay. If it is absent of active infestation or shelter tubes, but signs of prior treatment are visible to the inspector, and no documentation of treatment is provided, treatment will be recommended.
That makes no sense.
Exactly.
There are no termites, there are no signs of termites, but hey, it looks like somewhere in the past they had treatment. Oh, you need to get treated again.
What's the
You
same
can't
thing
prove
with
it.
the air
You can't prove it.
treatment they
It's
don't
the same thing as the air
Yeah.
conditioner for
That is
FHA
ridiculous.
appraisals. If there's
Well,
an air
what they're
conditioner
going to
that's
say,
working-
and I think it's a racket, guys. It's a racket, but here's what I'm going to tell you. What they're going to say is that Homes that have been previously treated because there was previous infestation, and they are much more likely to get a reinfestation. That's what they're going to say.
He'll say no treatment.
But I mean, I'm not a
So what if
insect,
you only own a house for like 3 years?
and it was treated before you owned it.
Exactly.
That was.
That's
You're gonna
what I'm
get-
saying. If
you're
I'm
gonna be
a
paying
list
for
They're
agent,
gonna get hammered.
you get your ducks in a row, you can call OPC like that, call the major
So-
players to see if they have for that property evidence.
So everybody's going to get crushed for the next 5 years, and then after that, everybody's going to have record of treatment. Is what's going to happen.
So we got 5 years to make a lot of money.
Yeah.
Let's go. Come on, guys. Who's with me?
I mean, maybe they could.
Records for at least 5 years.